Today we're diving into discussions about some of the incredibly tragic but very predictable consequences of the overturn of Roe v. Wade. These are 4 lives that we have now known to have been lost, having been deemed probably preventable in the absence of the now quite restrictive abortion access legislation in many states. These are not hypothetical, they're real stories, and they come from maternal mortality review committees in Georgia and Texas, meaning these aren't biased, although again, everybody has bias, they aren't made political. A maternal mortality review committee reviews every maternal death in the US and makes an assessment as to where things potentially went wrong. And this is a standard that's happening with all maternal deaths, not just those that have happened since the overturn or those thought to be related to it. They aren't generally released to the public, but ProPublica has managed to release 4 of these reviews. And we're going to talk about what happened in their situation, where the laws created the environment for these things to happen, and why it's important for us to continue to review these and discuss them. You will inevitably start hearing about this more because these committees are reviewing cases from a couple of years ago at this point, because it takes a lot of time to get to the point of having all the information to review and actually reviewing it. You will notice, if you are familiar with this topic or any of the discussions around it, that the cases will be eerily similar to Savita Halappanavar, who was a 31-year-old dentist in Ireland who died after their abortion laws became quite restrictive, and her story ended up being the push that they needed to overturn their very restrictive laws. Unfortunately, we haven't seen quite that same response to these, quite the opposite in a lot of circles actually, but I think it's important for us to go through them, understand them, and most importantly, not to forget these women who should be here and are mothers who left behind children and daughters who left behind families, who have loved ones that are mourning and are victims of blanket abortion legislation. First person we're going to talk about today is Amber Thurman. Amber was a mother in Georgia who had a 6-year-old, and her death has been reviewed by the Georgia Maternal Mortality Review Committee. They look at all the deaths in Georgia that happen pregnancy-related or during pregnancy, and they try to go over them, basically any death that occurs during pregnancy, or I think it's within a year of the pregnancy ending. So the Georgia Maternal Mortality Review Committee determines pregnancy relatedness, causes of death, contributing factors, and then they make recommendations on how to improve maternal outcomes. This is a very important review process, and we do it for a lot of things in medicine. And I think the fact that most states have these review committees, particularly for maternal mortality, is important, both in general health understanding, but also to understand that when we're talking about these, this isn't just, oh, someone picked apart this medical situation. It's a standardized process with a lot of expert involvement and a always similarly structured process to go back and decide this is definitely preventable, not preventable, probably preventable, etc. So the review committee assigns a factor of preventability to every maternal death. That's their whole job. In the summer of 2022, Amber Thurman was 28 years old. She's a single mother, and she had a 6-year-old little boy. She was a medical assistant, and she really wanted to go to nursing school. She had recently moved out of her family's home and into her own apartment, was getting on her feet and really getting her footing as a single mom. Anybody who's been a young mother, especially a single mother, knows it is very hard to get your footing. And it just adds another layer of tragic to me that she was finally doing that and starting to be able to follow her dreams. Because of that and how hard it had been for her to get back on her feet, move out, get her own apartment, be the single mother that she wanted to be, and by all accounts, her friends and family have said she was a wonderful mother. She found out she was pregnant, and when she found out she was pregnant, she decided to prioritize her current life and her young son. I think it's important that we stop here and talk about the Turnaway study just quickly that says people who are seeking abortion, and this is based on lots of data, this isn't something I'm just making up, it's data-based. People seeking abortion who are turned away have an increased risk of poor outcomes for their currently living children, poor socioeconomic status for them and their children moving forward, more likely to stay in abusive relationships, and are just overall going to experience children who are less healthy and less well off when compared to people in their similar situations who were seeking abortion and weren't turned away. So she made a decision that was prioritizing for her life, and the life of her young son. Unfortunately, Georgia's 6-week abortion ban had gone into effect on July 20th, which was right around the time that she found out that she was pregnant. I also think it's important to add in here that 6-week abortion bans are effectively complete bans. Incredibly difficult to find out you're pregnant, make a decision, get in with someone, and access abortion care in that 6-week time frame. Nearly impossible, most would say. So she attempted, because she was already outside of the time frame of 6 weeks, she decided that she would look for an abortion out of state. Importantly, something that when all of this happened, everybody said, just go out of state, right? No, we're not banning abortion. Just go out of state. Not something that is possible for a great majority of people, but for Amber, it was. So she decided that at week 9, she would go to North Carolina and seek a surgical termination with a D&C. She ended up going on the 13th of August. She woke up at 4 a.m. to make that drive, undoubtedly having to take off work, secure childcare for her very young son, and find someone to accompany her. Unfortunately, she hit serious traffic on the way, and the clinic, because they had been completely inundated with people coming from out of state where there are more strict abortion restrictions, was incredibly busy and not going to be able to see her because she was going to be more than 15 minutes late due to that traffic. She was offered a medical termination with mifepristone and misoprostol. Still a very acceptable manner of termination at 9 weeks. 94% of terminations in the United States happen below 13 weeks, most of those being medically induced, meaning take a pill, have a miscarriage. So clinic employee offered her that, counseled her on it, and she decided that she would take the medication. She took the first half of that pill regimen on that day, the 13th of August, which would be the mifepristone, and she took the next medication, which would be the misoprostol, the following day. She experienced what would be typical symptoms after she took the medication. So she started having some cramping, and then she started having some pain. Typically, you expect the pain and cramping to be a range of severity. For some people, not that bad. For some people, really awful. But in all cases, it should be rather short-lived. Once you start having pretty significant cramping and bleeding, it should go away fairly quickly once the now medically induced miscarriage has completed. But she wasn't experiencing that. She was having pain. It was going on, and she was bleeding heavily, soaking through more than a pad an hour, which is quite heavy, especially if it's going on for many hours. So the night of the 18th of August, she has not sought medical care for what I would imagine have been included in her list of things that is not normal and you should seek care. Why would she not do that? I think we can all come up with a whole host of reasons that she would choose not to, but the biggest factors for me in regards to this case are, I went across state lines to get medication that my state says should not be allowed and is illegal here at the gestational age that I'm at. Am I going to be prosecuted for doing something that is illegal here but was legal where I had it given to me? Am I going to be given treatment or treated differently or refused treatment? All of these things must be going through her head. On the evening of August 18th, she vomited blood and she had a syncopal event, meaning she passed out or lost consciousness at home. Luckily, she was accompanied by her boyfriend and he called an ambulance, which arrived at their house about 6:51 p.m. At 9:38, she was finally assessed by doctors. At that point, she was reporting that her abdomen was very tender, that she had a foul-smelling discharge, and the ultrasound showed that there was still some retained products of conception or tissue in the uterus. She also had a very low white blood cell count. So they started her on IV antibiotics and an IV drip, and the obstetrician at that time suggested a D&C the next day. This is absolutely the right answer. When someone has had a miscarriage or an abortion that is incomplete and presents with foul-smelling discharge, generally being unwell, a ultrasound showing there's retained products, and they're very tender on their tummy, the answer to that is D&C. There's no other answer. Antibiotics might bridge you to that point, but she needs a D&C. I'll pause here for a second because there's a question in the chat that I think is relevant. It took her 3 hours to be seen, ? I don't think this is necessary necessarily outrageous. She was probably taken to the emergency department. At that point, she had been stabilized by the people in the ambulance. So whether she was in the waiting room or in a room waiting to be seen, likely what happened is she got an IV in the ambulance, regained consciousness. They initiated doing some lab work and discussions with her. They probably went ahead and started some IV fluids. And then the time it takes to, get to the hospital, settled in a room, IV place, nurses do the intake, and you're not a patient who's actively dying. At this point, she was sick, but she wasn't on the edge or brink of death, as we will know because it's quite some time before she gets there. That is probably quite reasonable for someone coming in like this. You have to think that the other things that the hospital's taking care of include major car accidents, people who have lost limbs traumatically. I don't know that that's the part that strikes me as unreasonable, at least in my medical opinion from looking at the very limited information that I have in front of me. So they put her on antibiotics. Plan was nothing to eat or drink after midnight. We should do a D&C in the morning, which is using suction to clean out the uterus, remove the probably infected retained tissue. At 5:15 a.m., she had had 5 liters of fluid. I cannot express to you how much fluid that is. It's wild to me that they gave her that much. To me, that says that she probably had very low blood pressure, which is in keeping with her now being in septic shock. And she had had quite a bit of bleeding, I would suspect. She was noted in the chart to have rapid breathing, to have risk of bleeding out, to have low blood pressure. All of these things are alarming. This person is incredibly sick. Medical staff then in the notes says that they are thinking she should have a D&C, but is wary because of the newly criminalized D&C procedure. So instead, they increased her antibiotics, did some testing for various infections, and put her on something called Levofed. She was very, very sick at this point and unstable. At 6:45, they took her to the ICU, reasonably so. Anybody on Levofed should not be on the main unit or in the emergency department if they've been there for a while. And she was still having blood pressure drops at that point. So at 7:15, the staff then, again in the notes, appears to discuss D&C. However, by 9:15, Amber's organs started to show signs of failure. I don't know exactly what this means, but it likely means, if I had to guess, she was starting to go into some kind of renal failure or acute kidney injury, and her kidneys probably were not working as well as they had before. There can be a lot of different things that are end organ damage related to sepsis, but usually the kidneys are the first affected. By noon that day, the intensive care doctor was saying to the O&G or OB-GYN group, hey, she's still deteriorating. What are we doing? And by 2 p.m., she was finally taken to the operating room. In my opinion, this should have been done way earlier, but I don't blame the doctors. And I will go over in just a moment why that is not the appropriate response to reviewing this. By then, the situation was so dire that doctors started with an open abdominal surgery. They found that her bowel needed to be removed, but it was too risky to continue operating because there was not enough blood flowing to the area, a possible complication from the blood pressure medication. The OB performed a D&C, but immediately needed to continue with the hysterectomy. I cannot express to you how incredibly sick they had let her become before going to the operating room. During the course of this surgery, her heart stopped, she went into cardiac arrest and asystole, meaning she had no heartbeat, and they were unable to revive her. Now let's move on to discussing how this relates to the 6-week law. As with any attempt to legislate something that is a very much needed life-saving health procedure for a lot of people, the wording of the law in Georgia, like many others in this country, leaves a lot to be desired. On top of that, it is impossible when you are the person in charge of deciding when someone is sick enough to qualify for the exception that their life is in danger to distinguish, if I do this procedure now and the patient is fine, am I going to be sitting in front of a jury of my peers who is questioning whether I actually did an unnecessary abortion procedure with their evidence being, see, the patient is alive and she's fine? Or am I going to be in a situation that these doctors are in, which is completely unfair for both the doctors and obviously more so for Amber and her family, where the patient dies and now I'm in front of a jury of my peers going, actually, you let her die, that's medical malpractice. When does that flip happen? And the answer to that is you can't tell me, and I can't even tell you. And that's why this is not ever going to be a situation where these laws are effectively preventing all the preventable deaths. Because when I'm having to balance that and come up with when does it flip without the benefit of knowing in foresight if the patient lives or dies, that's an impossible situation. So yes, most people will be fine. Most young, healthy people, even in this situation, will be fine. For every Amber Thurman, there are hundreds, if not thousands, of people in her exact situation who don't die. But how many people dying is acceptable when they had a death that is almost certainly preventable, if not for these legislative efforts to control reproductive health care and access to termination? Let's go specifically through the Georgia House bill, though. The question then became, is there something in the wording of this bill that related to this delay in care? Or was this just medical malpractice? First off, I will say all of these bills have wording that leads to delayed care. But in this one specifically, we can look at it and I could tell you, I could have told you this would be a problem before this happened. So I have the bill pulled up here. This is House Bill 481 from Georgia. This is where they talk about what we're interested in here. Abortion means the act of using, prescribing, or administering any instrument, substance, device, or other means with a purpose to terminate a pregnancy with knowledge that termination will, with reasonable likelihood, cause the death of an unborn child, provided, however, that any such act shall not be considered an abortion if the act is performed with the purpose of. So she had already taken the mifepristone that she got out of state, and now she's in a situation where there is retained tissue and she has a septic uterus. However, they've defined here abortion as being any instrument or device that terminates a pregnancy. She is still very clearly pregnant. It doesn't say there has to be a heartbeat. And in fact, in the next subsection A, you can infer there doesn't have to be a heartbeat. So this is where we see removing a dead unborn child caused by spontaneous abortion. Do we see the problem here? Spontaneous. She had admitted to having gone to North Carolina, taking mifepristone to intentionally end this pregnancy. Something that those doctors never would have known if not for Amber just wanting to get the best care she could and be honest with her healthcare team. The outcome might have been different, but that's not on her. She shouldn't have to decide, do I tell my healthcare team the whole truth or not? This is ridiculous. They've said it can not be considered abortion if it's removing a dead unborn child by spontaneous abortion, but this is dead tissue, not spontaneous abortion. They do have the medical emergency part. So technically this part would count, but I will again refer you to at what point does it start counting and why are we putting people in a position to have to question whether or not it would be acceptable and at what point it goes from not acceptable to acceptable. I think it's also incredibly important to consider where the doctors were in the world, Georgia, the current volatility with regards to this topic, the extreme views of some people on this topic, and what you are up against as the obstetrician. I don't know what went through the first or second or team of obstetric doctors' heads or what was going on behind the scenes. However, even if they had been completely on board with immediately doing a D&C, knowing it might risk their license if someone came back and said it's not actually something that needed to be done, even if that was the case, which I'm not saying it was, you are then up against who do I need to help me get this patient to the operating room? I need an anesthetic doctor. So you've got to have them on board because you can't do this with no anesthetic. I need operating room nurses. So their personal beliefs or fears of what will happen are then also at play. And maybe they don't realize how dire the situation is. And you just can't find anybody to help you anesthetize your patient or be their nurse for the procedure. You can't just do a D&C by yourself. This isn't just one person making one decision. And the gray area of when it becomes unnecessary to necessary, medical emergency versus not, is real easy in hindsight, but it's not the same when you are sitting there in front of a patient having to make those decisions and get everybody else around you on board with it. Sadly, Amber Thurman's mother has been on TV and interviews and all of these things talking about this, and it's absolutely heartbreaking to imagine what her family and her young son have gone through. But she has been quoted as saying that her daughter's last words as she was being wheeled into surgery were, "Promise me that you'll take care of my son." And Monday, the 16th of September, would have been Amber's 31st birthday. This is very heavy, so please look after yourself. All I ask is that you be aware that this is real, this is happening, and although it is much more likely that you would be fine and you would not die as a result of not being able to access, it does not matter how low that risk was if you end up being the person who dies or it affects your mother or sister or daughter or family member. The percentage risk didn't matter. And I will ask you to, especially if you support these blanket legislations, really give consideration to how many probably preventable deaths we need before we stop saying, oh, well, here, they could have done this and that one, or this and that one, or this and that one. How many people have to die before we go, probably what we could have done is not made predictably deadly blanket legislation on this.